Hello, welcome to the U.S. Department of Commerce Commercial Law Development Program's overview of bid protests in the U.S. federal procurement system. My name is Charles McCarthy. I'm an attorney with the U.S. General Services Administration, GSA. I'm located in the Pacific Rim region in San Francisco, California. This presentation is a brief overview of bid protests in the United States federal procurement system. Here are some references for your use in connection with considering bid protests in the United States. The first is the Competition and Contracting Act, CICA, from 1984. This is an act which promotes maximum competition for U.S. federal contracts. The second thing I want you to consider as a reference is the Federal Acquisition Regulation, the FAR. Part 33 of the FAR governs bid protests, and you can reference that if you want to see how the implementing regs govern the bid protest system in the U.S. You can find those regs at www.acquisition.gov. And finally, the Government Accountability Office, which is a forum where many of the bid protests in the U.S. system are adjudicated, has a bid protest regulation at 4 CFR, that's Code of Federal Regulations, Section 21. You can find those regulations at the GAO's website, www.gao.gov. I hope those references are useful for you. This is a very brief and very general overview of bid protests in the U.S. system. The topics we're going to cover today are the basics of the bid protest process in the U.S. We're going to talk about performance stays. We're going to talk about agency corrective action. We're going to talk about the actual litigation of a bid protest. And then we have some discussion questions and a discussion problem for you to consider. So what is a bid protest? Protests are formal challenges to procurement decisions which are filed by private contractors either during a solicitation process or once an award of a contract is made. In the U.S., there are two species of protests. The pre-award protest, which is a challenge to errors or improprieties in the solicitation itself. For example, a solicitation may be challenged for being unduly restrictive of competition. The second species of protest in the U.S. is the post-award protest, and that's a challenge on any other matter. Generally speaking, a post-award protest is going to be a challenge to the source selection process and the award decision that the agency makes. I want to point out to you that a bid protest does not involve disputes about contract administration or the performance of a contract. Those disputes are adjudicated in another forum under a separate set of statutes and regulations. The bid protest in the U.S. system is its own species of litigation. I also want you to consider, as an acquisition professional, that in the U.S., a protest will always impact the acquisition lifecycle, and it will delay the award of a contract. A minimum of 2 to 4 months delay in responding to a protest is typical, even if the protest is denied. If the protest is sustained or the agency takes corrective action, it could be 6 months to a year of delay if the agency has to start its procurement process over. So these are very serious topics that an agency must consider when evaluating a challenge. The protester may file its protest initially at one of 3 places. It can file its protest with the agency, with the Government Accountability Office, GAO, which is an administrative forum, or it can file it at court, the Court of Federal Claims. If the protester determines that it will file its protest with the agency, it can have that protest adjudicated either by the contracting officer or the agency protest official. If it does not prevail at the agency level, it can essentially appeal that decision at the GAO or at the Court of Federal Claims. Alternatively, a contractor may initiate its protest at the Government Accountability Office, GAO. This is by far the most common forum in which bid protests are filed in the U.S. The Government Accountability Office is part of the legislative branch of the U.S. government. It is in charge of making sure that executive agencies are properly spending their money, including properly engaging in acquisitions. If a protester files at the GAO and is unsuccessful, it may essentially appeal that decision of the GAO at the Court of Federal Claims. Finally, the third option for a protester is to file directly with the Court of Federal Claims, COFC. If it is unsuccessful at COFC, it may appeal that decision at the Court of Appeals for the Federal Circuit, CAFC. And then, in a very rare circumstance, a decision against the protester at CAFC may be appealed at the highest court in the United States Supreme Court. This is a very rare circumstance. Most of the bid protests in the U.S. are adjudicated with finality at the GAO, the COFC, or in some cases, the Court of Appeals for the Federal Circuit, CAFC. It is very rare for a bid protest to make its way all the way to the Supreme Court. Who may protest? In other words, who has standing to file a bid protest? Only an interested party can protest. An interested party is defined in GAO regulations as an actual or prospective bidder whose direct economic interest would be affected by the award of a contract or by the failure to award a contract. In practical application, this means, in the pre-award context, that an automobile manufacturer would not have standing, would not be an interested party to file a protest on an IT services contract. Why? Because an automobile manufacturer is not an interested party whose direct economic interest is affected by an IT services contract. By contrast, in the post-award environment, an offeror who fails to submit a proposal does not have standing to submit a post-award protest. You must have, at the very least, submitted a proposal in order to submit a post-award protest. One other thing I want you to consider when considering this concept of the interested party is that the next in line contractor, that is, a protest who appears in the rankings to be next in line for award, is almost always considered an interested party who can file a protest and who has standing to pursue a protest. Offerors number 3, 4, 5, 6, and on down the line are not next in line and therefore do not have automatic consideration for standing. Typically, those offerors, those who come in third place, fourth place, fifth place, and on down the line, will argue that the agency improperly evaluated their proposal. And if the agency had properly evaluated their proposal, they would either be the awardee or at the very least next in line. So there are many ways in which a protester can establish its potential for standing in order to submit a protest. It doesn't necessarily have to be designated next in line to be able to move forward with its protest to be adjudicated on the merits. When must a protest be filed? Timelines and deadlines are a critical consideration in any form of litigation, and bid protests are no different. In the pre-award context, protests that are based on the terms and conditions or improprieties or errors in a solicitation must be filed prior to the closing date for receipt of initial proposals. Common challenges in the pre-award context include that the specifications in a solicitation are unduly restrictive, the failure to include a mandatory provision in a solicitation, or that the evaluation criteria show an unfair bias toward incumbents. In the post-award context, a protest at the agency or the GAO based on any other matter must be submitted within 10 days after receiving actual or constructive notice of the basis for your protest. At the Court of Federal Claims, there is no specific time limit for the filing of the protest, but it must be within, quote, a reasonable amount of time. Common challenges in the post-award context are that the agency conducted a flawed evaluation, that the agency engaged in unequal treatment of offerors, that it failed to follow the evaluation criterion set forth in the solicitation, or that it engaged unstated evaluation criteria. Upon the filing of a pre-award protest at the agency or at the GAO, the agency cannot award the contract until the protest is resolved. If that protest is filed at the Court of Federal Claims, the protester must actively seek an injunction on performance. That is to say that the agency cannot proceed with the award of the contract until the pre-award protest is resolved with finality. Now, if the agency is confident that it will prevail on the merits of the protest, it may just continue with the evaluation and document its source selection, and then upon the successful resolution of the protest, immediately award the contract. In the post-award context, if an agency receives a timely post-award protest at the agency or GAO, it must immediately and automatically suspend contract performance. If the protest is filed at the Court of Federal Claims, then the protester must actively make a filing with the court to seek an injunction on performance. Now, I want you to know that an agency, either in the pre-award or the post-award context, can seek to override the statutory or judicial performance stays by showing that an urgent and compelling need exists, or that the override is in the best interests of the United States. Now, the agency's decision to attempt to override the stay can be itself challenged, and those challenges are always adjudicated at the Court of Federal Claims, regardless of whether the protest is originally filed at the agency level, at GAO, or at COFC itself. In practical effect, an agency's attempt to override a stay of performance is a very high threshold. That is to say, the case law that has developed over the years at the Court of Federal Claims sets a very high bar for an agency to override a performance stay in the face of a protest. It is rarely done, and it is rarely successful. Typically, upon the filing of a pre-award or a post-award protest, the agency cannot move forward with its procurement process until that protest is adjudicated. One of the ways that an agency may respond to a protest is by taking corrective action. This is a powerful tool that federal agencies use in response to challenges at the pre-award or post-award level. If the agency determines that there is a weakness or a flaw in its procurement process, in other words, if it reviews the protest and decides that there is some vulnerability to getting a sustain, then the agency may simply change course by taking corrective action. It does so by giving notice to either the GAO or the Court of Federal Claims and the protester. In the pre-award context, taking corrective action might involve taking the solicitation back to the agency and removing whatever offending elements exist, or redrafting the solicitation to make it more clear, or providing more time for offerors to prepare the offers if the requirement is complex. Any number of things the agency can do in the face of a pre-award protest. In the post-award context, same thing. The agency can take corrective action if it discovers that there may be some vulnerability based on the arguments set forth in the protest. The corrective action might involve reevaluating the offerors, redoing the award documentation to make it more clear, to make it more specific, to make its rationale more understandable, or it may permit offerors to submit revised proposals and redo the entire evaluation. If the agency provides notice to the protester and to the GAO that it will take corrective action prior to 30 days after the protest is filed, then the GAO will dismiss the protest without prejudice, and the agency will generally avoid having to pay any attorney's fees or costs to the protester. By contrast, the agency may decide that it will defend the agency's procurement process against the protest and litigate the protest to decision. If, for example, the agency determines that the protest really has no merits, it will defend its action and litigate the protest. An agency attorney is always involved in the litigation of the protest and the preparation of the agency's response. Particularly at the agency level and at the GAO, the litigation is meant to proceed as swiftly and efficiently as possible. To that end, discovery is actually quite limited. It's limited to the exchange of relevant contract documentation. Generally, there are no depositions in bid protest litigation. A protective order imposed by the GAO or the Court of Federal Claims will protect and limit access to any trade secrets, confidential business information, and information that otherwise would result in an unfair competitive advantage. In other words, a protester cannot file a protest and thereby gain access to the private or confidential or competitive business information of its competitors. A protective order will restrict the disclosure of that information to the GAO or the judge and the parties and the attorneys for the parties to the dispute. Now, generally, protests involve the preparation of documentation explaining and defending the agency's procurement rationale. At the agency level, this is the least formal of protest forums. The agency attorney working with the acquisition team will submit basically a report to the agency protest official, and a decision will be rendered within 35 days of the protest being filed, often much sooner. At the GAO, within 30 days of the protest filing, the agency must prepare what's called an agency report, which contains all of the relevant contract documentation and a full detailing of the agency's procurement rationale. Again, here, an agency attorney is responsible for drafting and filing the agency report, and a GAO examiner will render a decision on the protest within 100 days of it being filed. These GAO examiners are all experienced attorneys with an expertise in contract and procurement law. They are the administrative equivalent of the judge in these actions. Finally, at the Court of Federal Claims, the agency will be represented by the U.S. Department of Justice, with the agency attorney sitting second chair. The adjudication of a protest at CLDP can vary widely, depending on the complexity of the case and the court's calendar. A typical timeline for a bid protest case at the Court of Federal Claims could be 6 to 12 months until final adjudication. The protester has the burden of proof in a bid protest. It must demonstrate that the agency has taken actions that are clearly unreasonable or in violation of the law. And the agency protest official, GAO, and CLDP will generally defer to the agency's judgment on matters of discretion and the exercise of technical judgment. This is a powerful deference to the agencies in making procurement decisions. Generally speaking, the agency protest official, the GAO examiner, or the judge at the Court of Federal Claims will not second guess the agency's determinations on its own procurements unless the violation of procurement regulation or statute is obvious, or unless the agency has clearly acted unreasonably. Now, if the agency prevails in defending its actions against a protest, the agency may then immediately move forward with the procurement. However, if the GAO or the CLDP or even the agency protest official sustain the protest, the protester wins. At GAO, and this is generally true for the Court of Federal Claims, the following relief may be recommended. The agency must refrain from exercising options if the protest involves the exercise of an option. The agency must terminate an existing contract. The agency must recompete the contract. The agency must issue a new solicitation. The agency must award the contract consistent with statute and regulation. Or finally, any other recommendations as the GAO determines necessary to promote competition. Again, those are basically the remedies that the GAO may recommend if it sustains a challenge. The GAO may award costs, including attorney's fees and bid preparation costs, to the protester. This is the same in the Court of Federal Claims. That is a very serious consideration for the agencies because those costs and attorney's fees can reach into the hundreds of thousands, even millions of dollars. So avoiding having to pay those costs may be a very important consideration as the agency determines whether or not it will take timely corrective action or if it will pursue the full adjudication of the protest on the merits. Again, if the agency does not prevail in the protest, it will be subject, most likely, to the payment of the protester's costs, its attorney's fees, and possibly bid preparation costs. Those can be substantial. This slide is a representation of bid protest statistics from the GAO. I again mentioned that the GAO is the most common forum for bid protests in the U.S. procurement system. I'll leave it to you to take a look at these numbers and decide what they mean. I do want to point out two things. The first, on the fifth row of this table, is the sustain rate. And you can see that generally the sustain rate is between 15 and 20%, thereabouts. So not a very high sustain rate for protests. However, if you look at the row beneath that, the effectiveness rate, that rate is just under 50% consistently across the past 5 years. That effectiveness rate includes all of the protests that are sustained by the GAO, that is to say that the GAO agrees with the protester and that the agency has done some unreasonable action or violated some procurement statute or regulation, or that the agency, in the face of the protest, decided to take corrective action. So almost half of the time when a contractor submits a bid protest, the agency winds up taking corrective action. That's a very important consideration when thinking about the U.S. bid protest system. Almost half of the time, the federal agency will take some action in response to the protest. The 5 most common areas GAO protest is sustained are the following on the slide. I just want to point out a couple of them. Towards the bottom, one of them, lack of documentation supporting rationale. The agency could have behaved perfectly reasonably and in perfect accordance with statute and regulation, but did not document their process and protocol and procedure. If the agency doesn't document what it does in awarding a contract, it can be subject to losing a protest. So agencies are strongly advised to always record with documentation the reasons why it's awarding a given contract to one offeror over another. The last in the list is unequal treatment of offerors. This is a very common reason why protests are sustained. This is when the agency, for example, provides one offeror the opportunity to revise its proposal, but does not give that same opportunity to other offerors in the field. If that happens and a protest is filed, that protest will be sustained. Here are some discussion questions that you can discuss with your colleagues when considering the topics presented in this presentation. And finally, I've included in this presentation a discussion problem. It is a set of facts involving a government contract for fighting wildfires in the western region of the United States. I would recommend that you consider both sides, one of a protester, a contractor, and one of the government when you consider this problem. I want you to know that this problem is actually based on a real case, the protest of Global Supertanker. It's a GAO case. You can look up the actual decision by looking up the so-called B number of the case. That's the B414987 that you see at the bottom of your screen. If you type that into Google, you will get the full decision on this case, and it will help guide your discussion of this case. It's a very interesting one with an interesting set of facts, and it covers some basic procurement practices in the U.S. protest system. Thank you for engaging this training module on the U.S. procurement system, bid protests. I hope it helps you in your consideration of these important issues.